Hello guys, my name is Gauri Bandre. I'm an intern at LEXIS and Company, and my topic for today's discussion is falsifiers. So we'll talk about what is falsifier and how to know if a falsifier is being placed against you. What is the procedure to be followed to get out of the falsifier, and what are the punishment prescribed by the law. So, first information report, which is registered by the police and filed by the applicant against a accused, describes all the information of the incident. But in case of falsifier, all the information which is provided or the allegations which are given by the complainant are absolutely false and are made in respect to falsely implicate the person or harass in some or the other manner. So, how to know if a falsifier is being placed against you? So, first, there would be no procedure which would be followed by the police in case of arrest or anything like that. If a police is coming at your place to arrest you, then in that case, uh, you need to make sure when you are being arrested, and if in case you are being arrested by the subordinate, do they have the letter provided by the superior, or in that case if you are being arrested in non-cognizable offense, then do they have any legal notice before arresting you. If a female is being arrested, then when she is being arrested and by whom she is being arrested. Also, police can ask you to bring certain evidence to the police station, and also can ask you to settle the matters with the complainant beforehand. And they can be more friendly, or they can talk with you informally. They can keep you in lockup more than 24 hours. So these are few things which will help you to know that you are being the victim of false FIR. Because in case of real FIR, if is being placed against you, then there is certain procedure that is prescribed by a criminal procedure code, and that is needed to be followed. Uh, but in case of falsifier, there won't be any of this. It will be absolutely indirect and will be done through the use of power, or maybe through influence of certain people. So no particular procedure would be followed in that case. Second is what to do if you have already been arrested. First and foremost, you can take help of your lawyer. Okay, everybody has the right to consult a lawyer in case you're being arrested. You have right to inform your relatives or your closed ones. You have right to know your offense. You have even the right to anticipatory bail. So, what is anticipatory bail? It is prescribed under Section 438 of CRPC, and it is pre-arrest bail. Okay, the victim can get the victim can get bail beforehand, and it is provided in case of cognizable and non-bailable offense. Now, the accused needs to provide certain materialistic evidence and copy of FIR if he wants to file an application for anticipatory bail beforehand. And this application will be then sent to the Sessions Court or the High Court. If in cases of urgency, it can also be sent to the High Court. Through which the matter will be further processed, and if the anticipatory bail is approved, then you will be set free. If not, then the police have the right to arrest the accused. Next is you can quash off the FIR under section 482. Now there are certain bases for quashing an FIR. First is if the acts or omissions on the basis of which the FIR has been lodged does not constitute of an offense. If the allegations which are put forth by the complainant are false, or the doesn't constitute of any offense, then you will be set free. Second is if the offense which the FIR has been registered against the accused has never happened. So the situation is whole assumptuous and is false, then in that case also you will be set free, and the FIR will be quashed. Next is the allegations which are put by the complainant are completely baseless and very negligible. If the court feels so, the court will quash down the FIR. Next is writ petition. Under Article 226, the courts have the power to investigate matter in cases where the fundamental rights are being infringed. In that case, you can either apply for mandamus, prohibition, or habeas corpus. So in mandamus, the court will command the lower authority to follow certain actions, or maybe in prohibition they will prohibit the authority from working in a certain way. In habeas corpus, they can ask the body to be presented in front of the court. So these are few of the things which one can use in cases where they have been falsely accused by the complainant. Next is, what are the punishments which are given in cases of false FIR? First is under section 182, in which there can be maximum imprisonment of 6 months or fine or both. In case of section 211, the imprisonment can extend till 2 years or fine or again both. And under section 250 subsection 2, compensation can be provided to the accused person if he is being falsely accused of something. And also, the accused can file a complaint against the complainant if he is being defamed in some or the other way. We need to understand that false FIR is abuse of powers, which can be done by anyone, any superior authority, or people who have certain powers with them. In this case, everybody should know what needs to be followed and what doesn't need to be followed. And so yeah, that's it. This was everything that one should know if a false FIR is being registered against you. I hope you liked this video. If you did like this video, do subscribe to this channel. Thank you.